Serena, you're on mute.
Hi. So we'll go ahead and start that over. Hi, my name is Serena. I am the Innovation Center Manager over at OneValley in Silicon Valley, and I'd like to welcome everyone today to our webinar event called Open Source Legal Issues with our partner Oracle for Startups and Lowenstein and Sandler. I'd like to talk to you a bit today about Passport by OneValley. Passport is the world's most comprehensive digital innovation platform connecting entrepreneurs and emerging startups with access to vital resources, networks, and significant savings on essential business tools. When you join Passport by OneValley, you get access to over 25,000 members, 140 mentors, 450 investors who can take a look at your deck, give you advice, and you can unlock access to over $1 million in perks and resources. What's exciting today is we'll be raffling off a whole year free of Passport by OneValley. So stay tuned, turn on your video. We'd love to have a really interactive audience. And if you stay until the very end, you may be the person who wins our raffle, and you can get access to Passport for a year, and we'll email you directly to get you set. Today we have Rohit Jain from Oracle for Startups, and we have Bryan Sterba with Lowenstein and Sandler. They'll be talking to you today about open source legal issues. And without further ado, I will pass it on over to Rohit.
Thank you, Serena. Hi, everyone. Good morning, good afternoon, good evening. My name is Rohit Jain, and I'm North America Business Development Lead, Oracle for Startups, based here in San Francisco, California. I'm fired up to hear Bryan Sterba from Lowenstein Sandler discuss a very legal important topic in how to enforce an open source policy and creating a strategy for your startup. Oracle for Startups puts on many different workshops to support the startup community, and I'm excited for this workshop series with Lowenstein Sandler and OneValley. I'd love to just give you a brief overview of Oracle for Startups and how startups can benefit from our program. Moving on to the next slide. So today, startups, they have multiple options for which cloud provider to utilize, and value, performance, and security are some of the most crucial factors. And they're just a few of the reasons startups choose Oracle Cloud. Last month, I spoke to a startup and saw their cloud bill rise, and they decided to migrate to Oracle. In today's startup environment, every dollar of savings matters, and we save the startup over 70% off their cloud bill. Oracle has 430,000 plus customers globally, and for startups in our program, you get the opportunity to potentially get in front of them. And we don't take any equity and don't charge any fees. And lastly, if you could just move on to the next slide, Serena. And any startup can sign up for our program. It's open to startups and innovators worldwide. For any questions, please email me, and I'll drop my email in the chat. And we'd love to have you join our program. It's really easy to get started. Just fill out the short application and let's get rocking and rolling. Thank you, and I want to pass it over to Bryan.
One second. Sorry about that, folks. Not great at doing two things at once. There we go. Hope everybody can see the slides. So my name is Bryan Sterba. I'm counsel over at Lowenstein Sandler. I handle general IP issues. A lot of it is in the M&A and startup context. So whether it's early stage startups figuring out what their IP portfolio should look like, what their commercial contracts should look like, general startup issues, or developed companies that are looking to do a financing round or a full exit. I handle the IP diligence issues that come up and just sort of getting everything in order so that people feel comfortable investing in the startup, and that the founders feel like all their issues are nice and tidy when an investor starts looking under the hood. Today, we're going to be talking about open source software and the issues that go with that. It's something that comes up in both of those contexts that I mentioned. Some startups are really buttoned up about this from the get-go. More typical for experienced founders that have had these issues come up and realized better to be at least somewhat on top of it from the beginning. It also comes up in the later stages, and more frequently in the later stages, where someone's doing a C round. They've never had anyone look at their software code before, but all of a sudden they have an investor that's saying, you know, we want to make sure that all of your code is clean, that you have proper proprietary software and open source software, that they're mingling together without any kind of copyleft issues infecting the proprietary code. And they might look around and say, well, what's that? I don't know what any of that means. I need someone to help figure that out. So that's where we come in, along with different service providers who could do code scans and things like that. So we're going to talk about a lot of those issues today. And I noticed that there were a bunch of questions submitted beforehand. Some had to do with the open source software. Others were either general IP or general corporate questions. Because they don't fit in well with the program today that we're going to be discussing, what I think we'll do is, once we get through the open source presentation, we'll try to answer as many of those questions as possible. So please stick around. If not, I'm going to make my email available afterwards. So if anybody wants to get in touch, you know, spend 10 minutes talking about any of those questions that I'm not able to answer today, or anything else, or anything that comes up today, please feel free to reach out and do the best I can to schedule some time to talk. So what's on the agenda for today? We'll talk generally about what open source software is, or open source in general. It doesn't always have to be software. There's just a few principles that guide what makes something open source. We'll talk about the different license types. You have permissive licenses and restrictive licenses. The names are as simple as they sound. It's, you know, permissive ones you're going to be able to do a lot more with. Restrictive are going to have some of those copyleft issues that we were talking about. We'll go over the anatomy of an open source license. You know, what an MIT and BSD and Apache license look like. Those are those permissive licenses. And then we'll also talk about what a GPL license looks like. Those tend to be the more restrictive. What can go wrong? Like we said at the beginning, you know, if you have an open source issue that festers, or an open source policy that's not really sufficient, you could end up having a big problem when you come time for a financing. In fact, you could find out that it's too late to really do anything, and you can't fix a problem sometimes because your code is really built on sort of a house of sand of GPL, or more importantly, AGPL code, which would potentially infect the entire proprietary code base with these copyleft licenses. Obviously, that would be catastrophic if it happened. Very, very rarely does, but that's, you know, the significance here. It could really be terrible if you're not on top of it from an early stage. Talk about some other risks along with that, and we'll talk about what the operations team and lawyers teams are in, you know, combating this, right? OSS management policies, how you structure license agreements, consulting agreements, how you stay on top of your employees and consultants to make sure that they are, you know, really keeping the company's interest when it comes to open source management in mind when they're developing code. And we'll talk about what happens, you know, when you're ready for a financing round or an exit. So let's talk about that open source definition. What makes something open source as described by the Open Source Initiative, which is a conglomerate that sort of promulgates the open source movement for software as much as possible. So the rules are, first line to be considered open source by the OSI is there's free redistribution, as in the code that that has been made open source, that it actually is redistributable, that there is no barrier to that. So if the code itself, the source code is made available and it has a license that allows it to be redistributed to other people in the same form as it was made available, That meets definition number one. Number two is it has to be source code that's available. It has to be primary material that really can be exploited by a developer. Derived works. You have to be able to make derivative works as an end user who's looking at this code and looking to create something out of it. You can't be boxed in that you can only use the code as it was provided to you. Integrity of the author's source code, that the license says, hey, if you're going to make changes to my code as the original author, you need to say and show the changes. You can't redistribute the original code with edits in it, but not acknowledge that there's edits there. People have to be able to sort of figure out what the original and what a derivative work is. No discrimination, both numbers 5 and 6 here. Can't discriminate against persons or groups, can't discriminate against different fields, can't say, well, this can only be used in the healthcare context, but not in the financial services context. Distribution of license, the license has to go with it. You can't just provide code without a license for it. You'll see that a lot, and we could talk about that too, and what happens when that situation arises, because you'll see a lot of the time on GitHub, different pieces of code are out there and the author didn't put a license with it. Technically speaking, there is no license if that happens, and it's not really open source, it's just kind of hanging out there. We'll talk about that issue in a bit. The license must not be specific to a product, similar to what I was saying about fields of endeavor. It can't be, you can only use it for this type of product. License must not restrict other software. It can't say, well, you can't use this with Linux, or you can't use this with some other kind of software that it would operate with. And lastly, the license must be technology neutral. It has to be usable however the person looking to use it wants to use it. They can't be restricted only to a Mac or a PC, for example. Not that that really comes up too often. Let's just talk a little bit very briefly about the history of open source software. You had the Free Software Foundation that was founded in 1985. It was really built on this sort of moral and ethical movement towards getting software back in the hands of the people. Basically, they wanted it to be that you can, they didn't want big corporations sort of taking control of software development and being overly restrictive on how, people with access to a computer that were still back in 1985, they had their garage filled with a bunch of, large machines that they were, the few people were able to get their hands on them and actually start developing code. They felt like they were being stifled by big corporations that really, had control over operating systems and were making it impossible for anybody to really develop their own code and distribute it without having to run afoul of their license terms. And they wanted to be able to really get people the opportunity to build their code out, share it with others, build a community that was building on each other's works. And it was sort of this very anti-corporate movement. While the Free Software Foundation didn't really view free as free from cost per se, they were really pushing it back against this sort of corporate takeover of the software environment. And there's the Open Source Initiative. They came along significantly later in 98. They changed it to open source software. This idea that it's not really about being free, because free almost implies that you could do anything with it. It's open source, where the source code itself is available, but there might still be some restrictions, like the author's integrity type of restrictions we were talking about, where you can't just change the code and pretend it was yours, for example. You got to maintain those types of copyright notices, things like that. It was much more practical in nature, as opposed to being anti-corporate. It was more, how do we create a simple system for people to get their code out there? I'm sure there's a bunch of developers in the room who, whether you've worked in the past or, will at some point work for another company, where you might want to continue sending code back to the open source community, because the community in general seems to, piggyback off one another, and it helps individual software developers raise their profile by being able to submit code back to, the general repository on GitHub, etc. Then there's the GNU Foundation that, they're sponsored by the FSF, and they were responsible for where'd it go? And they made possible they were made possible by the development of that original Linux kernel. So brief history lesson. Never comes up in the legal context, but thought it'd be helpful to spend a couple minutes there. Let's talk for a bit about the permissive versus copyleft licenses and what the significance there is. So permissive licenses, they're the ones that they have, some restrictions, not necessarily nothing on them, but limited restrictions about how you will, distribute the code if you want to put it in your own work. You'll have to give a copyright notice generally. You'll have to give disclaimers. There might be on something like Apache, there might be a patent license involved, but the general idea here is that you are letting people create derivative works more than anything else, and that you're letting them distribute those derivative works to others without necessarily needing to give their code back to the community. Copyleft, on the other hand, requires licensee to distribute those derivative works under the same license. So if you take a GPL, copyleft licensed piece of code, and you build your software on that, you have to, if you distribute that code and make it available to others, you have to make the source code available to everybody, because you have now accepted those license terms and requirements, which say that, hey, I'm only letting you use my code because you're guaranteeing me that you're going to put your code that's built upon it back into the community. This comes up all the time. This is this sort of key point in all open source software law, is whether a piece of copyleft licensed code was used, whether that code was distributed, which we'll talk about in a minute because the word distributed is not entirely clear what it means, and then whether it's really a derivative work. Are you including a copyleft piece of software in a sort of larger aggregate work, or have you built your code really upon it? If those sort of triggers are met, that you've built upon it, that you've distributed it to others, well, then the copyleft license applies to your code also. So a lot of businesses, the vast majority, don't want their source code made available to the public. If that's the case, you want to avoid using copyleft software as much as possible. And when you are going to use it, you got to be very careful. You got to make sure that it's not being used to create a derivative work that is being distributed to the public. And a lot of my time gets spent trying to either, parse out that copyleft code and figure out how we could replace it when the issues arise, or building policies to allow people that have, a whole software development team, giving them the sort of freedom of action to still build out the code as they see fit, but without really infecting the company's core proprietary product with any of these copyleft licensed pieces of software. So let's talk a little bit about the anatomy of an open source license, sort of the MIT license. So the MIT license says, permission is granted free of charge to any person obtaining a copy of this software and documentation to deal in the software without restriction, including without limitation, the right to use, copy, modify, publish, distribute, sublicense, or sell copies of the software, permit others to do so without, and it's subject to the following conditions. So the conditions are just, you got to keep this copyright notice, right? It's a pretty simple condition. It doesn't have to necessarily be displayed, at every, just in the actual UX for the end user, but it does need to be in the back end, right? If somebody's looking at the code and looking at the program itself and looking through the files, they should have a notice file somewhere in there letting them see that, this piece of code was licensed to us under the MIT license. And then you also have to provide the disclaimer below that the software is being provided as is, along with the code sort of in that notice file. And this all makes sense, right? The original author of the software giving it away for free, they don't want to be responsible for anything. They don't want you or an end user coming back to them and saying, hey, you gave me this piece of code and somebody else I'm infringing their IP because I used it. Well, you didn't pay me for it. I didn't really contract with you for it. I don't want you coming back to me saying that, I owe you anything for your use of the software that I, put out for free. So that's the MIT license. It's a very common license. It's sometimes referred to as the bouncy castle license because the M, I guess, looks like a bouncy castle. It's sometimes referred to as the X11 license. It comes by a bunch of different names, but it's probably the most common license I see when looking through a sort of a source code database for a client. Then there's the Apache license, also considered usually to be a permissive license, and it has two wrinkles between it and the MIT license. First, that it says that the licensor grants no license to the trademarks except as required for reasonable and customary use in describing the origin of the work. As in, if a company were to, if Lowenstein Sandler were to license out its software and we said, hey, you can't use our trademarks except that you can use it to say the software came from Lowenstein Sandler. And we'd want that in the notice file. The second thing is that it requires licensees to cause any modified files to carry prominent notices stating that they changed those files. So if you're making edits to the software, you got to say prominently, usually right in the line of code, or right out somewhere close enough by, saying that this was modified relative to the original that this came from. Now, Apache grew popular in among commercial OS developers, and these wrinkles just sort of give them that higher sense of quality control and attribution while still encouraging that adoption. You'll see a lot of businesses that are built around open source software where they give out their core product for free and then they make their money off the support. These are the type of places that we're talking about that would typically opt for the Apache license. Then there's the GNU license, the GPL3, which it says just a couple of definitions before we get into the anatomy of the license. The program, when it talks about the program and the license, that's the copyrightable work that's licensed under it. So that's the original code that the author put out under the GPL license. To modify the work, that means making changes or adaptations that would require copyright permission. So if you were to do something that is not really, it's not clearly licensed under the original license. So if you were to make edits to the software, if you were to create a derivative work under the software, things like that would be modifications. A covered work is either the unmodified program itself or a work that's based on it. So that gets into that issue we were talking about before of that sort of line. Where are you separating out is your code sitting alongside the GPL code, this Copyleft code, or have they sort of mixed together in a way that created a covered work, which would now need to be covered by this GPL license? Then convey, it means any kind of propagation that enables other parties to receive copies. So the distinction there most often comes up in the SaaS context, right? If I distribute my software and make it available for you to download or use on your phone or a PC, not through a web-based application, but actually downloaded, I've clearly distributed the software. But if I have a SaaS platform where you're just interacting with my software over Chrome or Internet Explorer or whatever you would be using, I haven't really distributed you the code. It's sort of sitting behind the wall is what we'd say. We'd say it's sitting behind the SaaS wall. And when that happens, or when someone works through that, you are not considered to have conveyed the work, which is critical and comes up a lot in this context. Now, there is a variant on the GPL. It's a license called the AGPL, the Afiro GPL license. That particular license has a specific change in the language that says that even when interacting through a network, or in the context that we're talking about, if you are interacting even with software behind the SaaS wall, that is considered a conveyance under the AGPL license. So even in that context, you would be the created new code would be subject to that AGPL license also. Now I'll just talk about the GPL license and what it says. You must convey a covered work under the terms of the GPL. So if you have created a piece of code, like we said, and you've conveyed it in that way, you now have to make it available under the GPL license or AGPL, depending on the context. But like we said, what is a covered work? So compilation of a cover is a compilation of a covered work with separate independent works, which are not by their nature's extensions, which are not combined with it, such as to form a larger program. Those would just be aggregates. Those wouldn't be covered works. So for example, if you have, think about in the old days when we used CDs and floppy disks, putting two pieces together on the same CD, that CD is not a derivative work of the original covered work under the GPL. That's not going to make it that you now need to distribute your proprietary code also under the GPL license. Those two things are still sitting side by side. This doesn't help a ton, right? Like this gives us a little bit of context, but there really is not much guidance under the law on exactly where that line is drawn between a covered work that now is, or a derivative work that now has become a covered work, and your proprietary code has been infected. Where that line occurs is not very clear. But whenever you identify any kind of copyleft code in your repository, take it seriously, look at it, try to figure out what's happening, whether the two pieces of code really sit side by side. Maybe they interact with each other, maybe they don't. But if there is that interaction, try to figure out what level it goes to and whether there might be some risk of a covered work having been created there. So then there's the LGPL. The LGPL is considered the lesser GPL license, I guess. Usually it's applied to code libraries, which is why a lot of people call it the library GPL. That's a misnomer. Libraries, a collection of code that serves functions for multiple other programs, right? They're communicating back to these libraries. Those libraries often come under the LGPL license. And what'll typically happen is under, if you're using LGPL licensed code, it'll come down to how you're using it. If you're dynamically linking the library to your program, you've most likely not created a covered work, right? The two pieces of software are really just communicating with each other. They're not creating that real derivative work. You're just sort of accessing the information that's in the library. The library is performing its function. It's spitting back out an answer to your program. When that happens, we consider it not to have been creating a true derivative work. Now, if you're statically linking it, if the code is accessed while, during the build, while in the true executable, then that's statically linking. When you statically link a library, when that happens, you've really crossed that line over into a covered work, and you should figure out whether that's really causing this sort of LGPL license to infect your proprietary code. So there's just a little bit more on that, explaining, dynamically linking is they're really, two independent builds, and it's just sort of helping to run and execute the program by, whether it's communicating through call signals or something like that, but it's not really part of the build of your proprietary program itself. So one more quick note: combined library versus work based on the library. Way to look at that is, are these two things side by side? Or did you build upon that covered library? Did you improve upon it? Did you add to it? Really, we'd take that same GPL analysis if that was the case and figure out whether you've got code that's been infected. Now, let's talk a little bit more about that distribution. Like I said, mere interaction, that's not a conveyance. So sitting behind the SAS wall, you're not necessarily going to have distributed your code for that GPL analysis. So you'd still be okay if you create a derivative work with GPL code that's sitting behind a SAS wall, as long as it's not that AGPL license. So more and more companies are using copyleft materials behind that wall. It still comes up, right? People ask about it. People want to understand how it's being used. I have, every day a different investor that sends me a repository saying, hey, look through this code. What's going on here? We identify, 20 uses of GPL licensed code. And then we have to go talk to the founders of the company and figure out how they're using it. Is it all truly SaaS? Is it, are there, different APIs or different plugins that they send out to users to use their software that, do have that GPL? What happens then? Are the plugins open source? Are the plugins, entirely separate programs that they got from somewhere else so that they're not worried about them being copyleft? It all depends, but you're seeing more and more companies start to, build behind the wall, make use of this GPL code, make use of the community and support that's available for them, and not worrying as much about the copyleft implications because of it. Now, just because your company might have a product that's purely behind the SAS wall, that does not mean that you shouldn't have any kind of policies, or you shouldn't be worried about this stuff, because for one thing, there might still be some conveyances that you don't realize, but more importantly, you have to still at least worry about AGPL code. You have to also consider your product roadmap. Maybe in the future there will be something that is distributed. It's always good to have some level of open source hygiene, regardless of what your sort of model is, whether it's SaaS or conveyed. No distribution. So not conveying means that you don't have any obligation under the GPL or LGPL to release the source code. But that release of the AFIRO, like we said, the AGPL tried to close that loophole. Because originally when this came up, it wasn't that there was no desire to include SaaS in the GPL requirements. It was really just something that people, I guess for the most part, figured out, right? That the definition of a conveyance was viewed pretty quickly as not being conveyed if it sat behind the SaaS wall. And a big part of why that was, more than anything else, was just from a practical perspective. You don't necessarily really see code that's behind the SaaS wall. You just see, whatever is made available in the public UX. You can't see what's on the back end doing calculations, so you're not necessarily going to be aware of what's there. And with that in mind, people sort of took a much more lax approach to SaaS code use that involves GPL. So here's a handy little chart. This, feel free to take a picture if you want. This is a good way to, analyze whether your code is safe. So, that first level is figure out, am I distributing my software? Go through that quick analysis. Is it SaaS or is it truly distributed? If the answer is no, but third parties are interacting with it, that's sort of that SaaS approach. You have to figure out, is there AGPL in there? If there is, your AGPL program could be a derivative work, in which case you're not necessarily safe. Keep in mind that your users within your company might also be interacting with your AGPL code. This could be a totally back-end program. Technically speaking, that's not, if you created a new program and it's being used with people in your company, it's not clear whether your employees are considered interacting with it or whether you're part of one larger organization. Typically, the approach is people don't worry about it because most of the time, it's not really proprietary code that you're building a business on, right? You're just doing stuff on the back end. But that analysis should still be conducted, and you should figure out whether there's any kind of risk to having that code, or if a rogue employee or anybody else were to later on try to seek you to have you sort of release that code to the public. It's worth knowing, just what's in your proprietary database, even if it's not something that customers are interacting with. Going back to the other side of the sort of thought tree, have you distributed the code? If the answer is yes, then looking at what code is in there. Are they MIT BSD licenses? Are there some GPL and LGPL in there? If the answer is yes, you've got to figure out whether a derivative work's been created. If not, we try to sort of separate it out as much as possible, figure out what pieces are really covered by that GPL code. And if the answer is that we're not safe, got to have a long discussion trying to figure out how can we separate this out? What can we do to sort of reverse engineer and fix this sort of hole and problem? Now, if this happens, it's not the end of the world. It's not necessarily going to be the end of your company, right? Happens all the time. It's not good. It's not ideal. But it's a situation where we really want to figure out a way to remove that code. Maybe you write new code that replaces it. But we don't want to be in a situation where investors or anyone in the public finds that GPL code and then comes back and tells you, hey, you got to release this all to the public. Technically, it's already a violation, but it's still something that you could try to remedy at least as best as possible. So going with that, if you are in this not safe category, what are the things to think about there? Well, there's the legal implications, like we said. Technically speaking, you have violated the license, right? It's copyright infringement. It's contractual breach because there isn't a license that you were obligated to abide by. Technically, someone could sue you for damages. Usually not what happens. The more likely scenario and the bigger concern would be if someone were to find out, do they seek an injunction to have you release your code into the public? It's happened. People have been required to do that in the past. you want to get on top of it as soon as possible. If you are actually at risk to that, you do whatever you can to mitigate if that you find out that's a potential exposure that you would need to face. Practical implications. Well, okay, I'm using a GPL code, but it sits behind the SAS wall. Or I have this code, it's GPL, but you know, nobody real, you know, do I want to send out a, you know, update that gets rid of that code? Is that going to really sort of cleanse me? What am I going to do in that situation? What are the practical implications of it? You always want to think about this from a business perspective about what you are remedying in terms of the legal exposure, as well as what kind of efforts you need to make to remedy it, and whether that truly does close the loop, or at least, you know, take the risk from a 70% risk to a 20% risk. Those are the types of things you want to think about before you sort of have an action plan there. Implications, right? If you're going to be doing the financing in the future, you know that this is an issue that will probably come up. You want to cleanse this as soon as possible. Try to figure out what the cost is going to be, the actual financial cost in doing so, and do what you can to bring that down, or excuse me, not bring it. Do what you can to you know, take on that cost, figure it out while you can, because down the road it might be significantly more expensive. Or you look at it and say, down the road I'll have the money to pay for it. It's not going to really change or get any worse in the near future, so we can wait on this for now. And just one more point, this is true for all licenses. Technically speaking, you know, there are attribution requirements a lot of people don't follow with their open source licenses. You should always look and try to remedy any issues, even if they're not in the copyleft context. Commercial use of open source software just keeps going up. OSS made up 70% of code bases that Synopsys scanned over the last year. 98% of OSS are licensed under just the 20 most popular licenses. 99% of their scans contained OSS as opposed to all proprietary code. 67% of them had conflicts. 33% had unlicensed software. That's the times where, like I was saying at the beginning of this, you'll find code on GitHub, you'll put it in your database, and then it turns out that there was no license ever associated with it. When that happens, I mean, you got to figure out some kind of way to either get rid of the code or contact the author and have them provide a license, because you don't want to be using unlicensed software in your proprietary product. And then 75% of code bases scanned contained security vulnerabilities, right? We've only talked about the open source legal risk here, but open source software also has security vulnerabilities sometimes. It's good to stay on top of that, see what kinds of, you know, backdoors might be there that people on the internet are discussing, and try to limit whatever you know, security exposure you have in addition to your legal exposure. So what are some of the other risks of poorly managing an OSS portfolio? For one thing, it's bad business, right? Miscues can undermine the value of the company's product, because if you're using that GPL code, you might have a product that needs to be made available to the public, which is going to be great for your competitors, bad news for you. It can be a barrier to financing. A lot of different investors I work with, not necessarily at the very early stages, unless they're aware of a problem early on, but later stages, they will ask for an OSS scan. It's very typical in your later rounds that you will need to remedy any open source issues before anybody will put any money in at that stage. People want you to be more buttoned up the further you go, but to the extent that you can be on top of this from the early stages, have a policy, it'll save all those issues down the road and avoid putting you in a situation where you need to, you know, right before a closing, when you're doing 1,000 other things, rewrite pieces of your code base. So always good to stay on top of this early. And like I said, that security risk, right? A lot of security tools don't really look at open source security vulnerabilities. So staying on top of that also is a good practice. So when is open source going to be important? Well, let's say you have a software development agreement, right? You have a developer or development team that's putting something together for you. Maybe you're going to want to put in language in that agreement that, you know, specifies what they can do with open source software when they deliver the final product. Invention assignment agreements. Do you want your coders to be aware of open source requirements, and are they going to agree not to put open source code or copyleft code in your product? License agreements where there's OSS, right? You might be licensing a piece of code for your product or just for your business in general, and you want to know what open source software is involved in the creation of that product. You might want reps and warranties around that. You might want your policies, your internal management and governance to include what your employees can and cannot do. And then finally, in the M&A, representations and warranties for those financings or full exits that you're going to have specific reps you need to make about your company and the OSS used. So employee and contractor management, things you want to think about. How much autonomy do you want to give those employees and contractors, right? You might impose the restrictions I would recommend, and they'll say, there's no way I can do what you're asking me to, especially in the budget you're asking me to, and still comply with these guidelines. You need to figure out what's right for you. You need to figure out what's right for your business. You need to figure out what type of program you're running and whether it makes sense to really impose more or less restrictions on your employees to meet these requirements and limit your exposure for the future. Additionally, a lot of your talent might want to be able to interact with the open source community. They might want to be able to contribute code back to the community. If your policies say they can't do that, that might be a barrier for you attracting top talent. This happens a lot. I discuss with a lot of clients different ways to tailor their policies to give that autonomy to their employees while still maintaining some level of compliance. What kind of tracking might you want? If you have a non-employee, a contractor assignment that you're giving out, do you want them to submit a bill of materials after that shows every license that they've utilized? Not a bad idea. It might be burdensome, but I personally, if I'm building a program, I want to know each piece of code that's coming in there, and I just at least want to make sure that those considerations are being given by my contractors when they're building something for my product. And thinking about what your risks for non-compliance are going to be. If you're a SaaS product, very different from a distributed product. If you are more of a services company as opposed to a software company, also might not be as big a concern. But all things that need to be taken into consideration when you're building out those policies. And these are going to come up in your employment contracts, your invention assignment agreements, and those policies that you have. You may even have a policy on how contributor license agreements are used. Contributor license agreements are the sort of things that companies that have big open source projects out there on GitHub, if they allow people to submit something back to the repository, they may require a contributor license agreement. A lot of those have the same language. Microsoft uses them, Oracle uses them, Google, everybody seems to have these, and it just makes it clear that you're contributing this piece of software back to the community under the same license terms that the original code's made available for. In those contractor agreements, you want to look at those reps and warranties and covenants, and whether you're going to have any kind of scheduling requirements, thinking about what is really going to go into this contract, what impositions you're going to make on those contractors. So an example quickly is, for a developer agreement, any kind of independent contractor agreement, you'll define what the open source materials would be, what that code would be, and then give them, at a minimum, light rep like this, which just says that the vendor's representing that they're not going to incorporate open source code or combine any of their any open source code with any of the deliverables that they're going to be providing to you. Very simple, light rep. It's just saying, hey, you're building this for me. I want you to build it from scratch. I don't want you using open source software without my approval. And what that's basically saying is, get me a license, show me what's in the license. If it's fine for my business, I'll let you use it. If not, please don't use it. This type of warranty, if you're putting that in there and your developer ignores it and doesn't even mark it up, doesn't ask any questions about it, that might be an issue also, because most likely they are including open source code and they're just not telling you about it. So it's important to have these conversations with any kind of contractors and employees early on. Just let them know what you're worried about, what your business model is, how you view open source software. Almost always come to some resolution. You should include language in the contract saying what they're agreeing to do, right? Whether it's going to be just supplying a bill of materials, whether it's sort of whitelisting software, saying, hey, you can use MIT BSD, but don't use GPL. There are different approaches to take based on your risk profile, but have some conversation at least with all your developers to make sure that they're at a minimum aware of what using open source might do for your proprietary product. So these policies, they should, address employees' incorporation of open source software and participation in open source communities, because you also wouldn't want them taking, let's say they developed a piece of code, they took a piece of code from the open source community, they used it in your product, the license is okay, you're allowed to do that, but they want to contribute the, improvement that they made to the open source code back to the community. Your policy may say that you, the company, own that piece of software, that improvement that they made. How does that work? What happens there? Do you want the employee to not contribute it? That's the sort of thing you want to figure out before they start making the development, and have a policy that addresses it and says, if you're going to participate in an open source community, you need to let us know. You need to let us know what you're contributing if it is relevant to your work here at the company. Like we said, developers balk at a lot of these policies. If they feel that they're being too stifled, that might make them say, I don't really want to work with this company because I need to be able to contribute to the open source community and build my personal brand. But you could always find some compromise, some way of building a policy that will still let you bring in top talent and give them that autonomy while maintaining your compliance. So, whether it's a financing round or a full exit, you will very frequently see in any kind of software business, in the M&A or financing documents, you'll find an open source rep. This one is an example of a very buyer or investor friendly open source software rep. It requires the scheduling of all open source materials that are being used in the company, right? That might be a crazy long list. I've gotten literally 200-page, binders full of code for reps like these with, 10-point font listing out every piece of code and every license. And I have to just painstakingly go through that to make sure there isn't anything in there that I am concerned with, or at least find the things I'm concerned with and raise those questions. But, you may require as an investor or buyer that all that code is listed out. And you may also require the rep to say, as it does here in the second sentence, that all conditions of the open source licenses for those open source materials are being met, and that no open source is being combined with any seller-owned IP, things that are proprietary, and that none of this open source code is distributed with those companies' products that would require that sort of copyleft requirement, right? That would require the company's proprietary code to be licensed back to the open source community and made available at no charge. And with that, that's the end of my presentation. I know that happened somewhat abruptly. I actually thought there was another slide afterwards. Sorry, but maybe now we can shift over to some of those questions and see how many we can answer. I'm going to stop sharing my screen to do that, but for anybody who wants to reach out for any questions that we don't get to, feel free to take down my email. Shoot me an email. Happy to get in touch, set up 10 minutes to talk to anybody here about anything we talked about today, any other open source or general startup legal questions you have. Always happy to talk. Serena, I don't know if Rode, I don't know for the questions if I should go. I know some are in the chat and some are on our separate doc. I don't know what the best approach is here for now.
Brian, we shifted the questions over to the live doc. So if you just want to pull that up and, mention the questions that you want to answer, that would be awesome.
Sure. So I'm just going to go over to the chat questions for now. I see. With respect to non-discrimination and in light of current events, can something be OS and limit the purpose for which the license is usable for? I.e. purposes is limited to organizations operating in certain countries. And is that something I've ever seen? I have not. Really, the typical open source licenses are the ones that you see all the time, right? You see the MIT, BSD, GPL, AGPL, zlib, all these licenses are what you typically see. I very rarely see any kind of custom license, which would include language like this. The non-discrimination component of the open source initiatives definition is really just, saying there shouldn't, any kind of restriction like that would not truly be open source. Other people might consider it open source as long as the code is available. So I think it's possible to have open source software that would have a custom license that would have restrictions like these, and they would be binding restrictions. You just don't typically see it because the interest alignment isn't there. right? Someone who's contributing their code to the public for a totally new project, they most likely want other people to improve upon it. They want people to use it. So putting restrictions like this aren't always going to be helpful. There might be a situation where they have that interest, but I just haven't seen it, at least not yet. 2, what advice do you have for non-technical founders who built out their MVPs with dev shops and found traction? Should they be doing their own diligence on their code before raising, or wait until investors ask for it? What disclosures are they obligated to make during a raise? So that's going to depend on the documents, on the investor documents they're asked to sign. If you built out your MVP with a third party, it's not cheap to do an open source scan, right? If you wanted to contact Black Duck and have them run through your code, that could be $20,000, depending on how, do I advise people to do it? Usually in later rounds, when the company has some financing already available to them to tap into, they have money where they could spend it to get them to that next round if they think it's going to really help them, especially if they want to move quickly, right? Like when we're talking about C rounds and D rounds, at that point, you're usually working with bankers for private placements. Those move really quickly, so you want to get ahead of it. I can't tell you that I wouldn't advise you to do it. I think it's a good idea if you have the money to run that scan and get out in front of that issue, because you're much better off having, some plan for it, at least before the investors ask. At a minimum, I would want you to, think about these policies, think about a way to sort of present yourself about what you're doing in the future, maybe come up with a plan for an investor. But until you see the reps and warranties that the investor is asking for and requiring, you're not going to be able to really tell what disclosures you're going to be obligated to make. Most often, early rounds, you're going to be using the standard NVCA forms, which, the National Venture Capital Association forms for financing rounds. So that has a pretty standard rep in there. You'll usually either see that document or something similar, and it'll have a very light rep that basically says you don't use any open source code in a way that would trigger these copyleft restrictions. So if your MVP is a SaaS-based product, if there's a way for you to run through your code or look at or talk to the developers who built them out for you and confirm that no AGPL code was used, or any kind of viral open source code that applies to SaaS, non-distributed SaaS products, if you could find that out, that's ideal. Clean that up if those issues are there. If not, be able to tell the investors, we know that we're able to make this rep, that we have not infected our code. If you're distributed, do a little bit more digging, try to figure that out. But it's really ideal to have some answer for this, especially because there will be some kind of rep, most likely. I know we only have 5 minutes left, Serena. I don't know if you wanted to, I know you guys have the raffle. I don't know if there's anything else you wanted to say before that. I could jump to some of the questions we got beforehand. Otherwise, like I said, people can feel free to reach out to me, whatever you want to do.
Well, why don't you answer one of the questions that you liked that we pulled from the Eventbrite invitations, and then once you answer that question, we'll jump to the raffle.
Sure. So here's actually a really interesting one that someone raised. How do you protect your IP once you open source it on GitHub? Good friend of mine, like 6 years ago, was starting to build out a new project, and he was asking me, well, I want to open source it, but what happens when I want to build something proprietary? Is my proprietary product that I build upon that going to be open source? And what I explained is that the open source license that you make available to other people, that's just a license for them. That's what they're allowed to use the code under. You can always license your code under a different license separately. Or when it comes to yourself, you own it, you can do whatever you want with it. It does not mean that your new derivative work of your original open sourced piece of code is subject to that license. You could build upon it. The restrictions are not applicable to you the same way they're applicable to other people. Think about it like, you're just able to fork your code, and your fork, what you've done after you've submitted it to to GitHub, that is yours, and anything you build upon it is not subject to those licenses. Now, the question though is, how do you protect your IP once you open source it? Well, if you've open sourced it, that project, whatever is out there, it's out there, right? Like even if you were to say, I'm no longer making this available under the open source license, the damage is already done to the extent you'd consider it damage, right? People have it, people have downloaded it, people have redistributed it, and you can't really put that genie back in the bottle. So in that context, your code is gone. It's people are able to continue using it. You can't call it back, but it doesn't mean that you're not able to build something proprietary on top of it. Now you may have to answer an investor who does a scan one day and says, hey, this code is out there, it's public, and you've built upon it, but you could explain that you were the original author and that it's in your context proprietary, that you are able to build your forked code without needing to make that distributed to the public also. So I hope that's helpful. If the person who asked that question has something more specific they want to ask on that, happy to answer that now. Otherwise, we'll pass it back. So going once, twice. All right, Serena, go ahead.
Thank you so much, Brian. That was very insightful. And if you don't mind, can you drop your email in the chat for everyone who wants to get in touch with you? And Rohit as well, if you want to put in your contact information. I know at the beginning you did, but we had a few more people jump in a little bit after that. So thank you, everyone. I'm going to share my screen really quickly here. OneValley is really excited to team up with Oracle for Startups. This is part 2 of a 3-part webinar that we've put together with Rohit. I just want to reiterate, OneValley members, so if you have a Passport account, you get access to up to $5,000 in cloud credits, and then for your first year, and then following that, you get a 70% cost of credit for the next 2 years. So you get a pretty big discount in the following 2 years, which is an incredible deal. And in addition to that, we've covered all of the perks that you'll have access to with a Passport membership. A couple things to mention are you have access to 140 plus mentors that you can, drop into their calendar, set times with them, talk to them about your business and how to scale and how to grow. You can unlock access to over $1 million in perks for your business. One of those perks being Oracle for Startups, and so many others. Without further ado, we'd like to announce our winner. And that is Gilberto Gandra. Congratulations. Thank you so much for participating in our webinar. We'll be in touch with you on how to exercise that Passport membership in an email separately.
Awesome.
And lastly, thank you for everyone who stayed on this webinar. There was so much to learn, and of course you can reach out to Brian for additional questions. We just want to highlight a few more events that we have coming up. The third part of this 3-part series is going to be January 19th. It'll be decoding legal topics for startups at Series A and beyond. So we'll have Carl Hessler from Lowenstein Sandler, and Rohit will be on that call as well. Additionally, we have a couple more events hosted by OneValley. We have our exciting event in Boston, to spotlight Boston startups on the 28th, and another event, how to build an MVP with no code, on the 20th. So be sure to sign up for Passport. You can set up a free account and RSVP to these events as well. Thank you, everyone.